He's dropping. He's listening to our conversation. I've asked him to move aside and he has refused. This one, I don't know his name. It is completely untoward and disrespectful of the court process that an officer can abuse a citizen's right to have legal counsel prior to. My next point would be, we do not have a director of public prosecutions. So I do not know who has authorized the prosecution of the, or even the registration of the charges that Mr. Victor Muller is intending or proposing that they read to you.
So we
don't have a DPP, there is no authority to charge. We must remember that this is not the normal criminal prosecution. This is a political prosecution. I don't want to go to the details of the chargeship because my colleague will. But it is important to note what I've just been told right now by my client, that they were arrested on 19th. And they are being produced in court on the 24th. In total violation of the constitutional rights. They have been held in the cattle. They have not been able to talk to anybody because their phones were confiscated. And this is what, but very similar to what they said in the earlier case. The police have this abnormal habit of confiscating people's phones so that they incapacitate them from even communicating with their lawyers, with their doctors, with their family, with their wives, with their husbands. What is Kenya going? This court must protect the rights of citizens. A country's decency is measured by how it treats the weakest, especially when they are arrested. If you look at the charges on the charge sheet, the copy we were given, they have how many charges? They have 5 counts. Purportedly committed on 2 different dates. And the instructions I have right now from Mr. Njenga is that he was arrested on the 19th, taken to a place he doesn't know, and blindfolded. He's now telling me they were recording statements when they were blindfolded. The court cannot countenance this. Must reject these charges. Anyway, if you look at the entire charge sheet, in respect to the number of counts and the number of dates of their alleged offences, there is only one person stated as a witness, Mr. Kemboy Rob, who is a police officer. Meaning, this stated that others to be stated, they are going to be manufactured. What it means really from the face of the charge sheet is that the investigation is incomplete. Because how else is it state one witness who is a police officer and say they are going to state others later in life? When and why? if they had investigated the case properly, they would say we have so and so, Aaron Dubi, Mr. Mnyeki, and others as witnesses, and Ms. Victor Mule as a witness.
We have a spy, and I think this is premature. We could have taken and for good order, they make the application, we make our application. You give a consultative view. I thought that would be more professional and for good order.
I don't know what Mr. Mule thinks is good order if they are conducting themselves unconstitutionally. The order, good order is in the Constitution. It's not found inside a charge sheet. All I'm saying is that this charge sheet should be rejected. You will see duplicity. The accused persons have been held incommunicado and are constitutionally beyond 24 hours. Having been arrested on a Wednesday, they would have been produced in court on Thursday or Friday latest. And lastly, Your Honor, let me say this. My heart is bleeding. No, whether you put it or not, I think I need you to understand, Your Honor, with utmost respect, that we are descending into a police state. See, these fellows were brought here very early in the morning. We were lied to that they would be taken to Kahawa. I was in Kahawa. They were brought here, they have been kept in, not in the cells, but in the car, outside, some car. And I personally went there to try to see them. I was denied access. What kind of country are we doing if the court can't take control of itself and its precincts? It's just like Parliament has the privileges that nobody can be arrested within the grounds of Parliament. I think nobody should be given injustice in the grounds of a court premises. These fellows have been denied their justice within court premises, and it is completely unjust. But why then lie to counsel? Why deny them access to counsel?
There's an issue of lying. That is the police. The people who arrested them.
It is important.
They're the one who, if they lie to you that they're taken to power, I think they're the one who lied. It's supposed to be.
No, Your Honor, I very humbly and respectfully disagree with you. It is important for you to query the police and the prosecution whether they actually say it so that you can decide whether to admit this charge or not.
Also to hear from the prosecution.
Your Honor, with your kind permission, my colleague Mr. Awit will address you, but will also address you. But we'll start with Mr. Awit.
Your Honor, Ms. Kamburugu reminds me that he's also part of the prosecution team. However, Your Honor, with a lot of humility and respect for the learned senior Mr. Njenga, we will pray that these proceedings be a little more organized, number one. And number two is that Mr. Njenga should be a little more clear on the nature of the applications he's making. If I got him right, one of the applications learned senior is making is that to reject the charges brought before you. And my understanding is that he's premising that application for rejection on, among other grounds, number one, a question of duplicity of the charges. Mr. Njenga appears, I'm not sure he'll clarify, to be asking you to reject the charges on the grounds, number one, that they are bad for duplicity, and number two, that there has been a violation of certain fundamental rights and freedoms violation of certain rights, fundamental rights and freedoms under the Constitution of Kenya 2010. And finally, number 3, that as we speak, there is no substantive holder of the office of the Director of Public Prosecutions. If I got him right, I would like to respond to those 3 issues. And as I do so, because these are very serious constitutional issues raised by the Learned Council, is that this court can only operate within the confines of its jurisdiction. Your jurisdiction is defined by Section 8 of the Magistrates' Courts Act. And because of the jurisdictional issue, I'll start from that. That section limits your ability to hear, entertain, and or determine 8 of the Magistrates' Court Act 2015. That for good order, you can only hear or entertain and determine issues relating to alleged violation of fundamental rights and freedoms limited to Article 25A and B. Article 25A and B of the Constitution. And so that with a lot of empathy and sympathy, anything outside that falls out of your jurisdiction, and a proper application on the basis thereof is vested in the High Court by dint of Article 1653 of the Constitution. Having said so, the officers of the Director of Public Prosecutions, or said differently, the mandate of the Office of the Director of Public Prosecutions is exercised directly by the Director of Public Prosecutions under Article 157(1), or in terms of delegated authority by officers appointed, including the Deputy Director of Public Prosecutions. We have 2 of them before you this morning, and the signer, if that were an English word, of the charges before you, the approver of the charges, Mr. Murugu, who sits before you this morning. To that extent, the charges were properly reviewed and approved. And the validity of the charges as far as the existence of a substantive holder of the office does not arise. For clarity, the departure of Mr. Nurdin Haji from the office of the DPP did not invalidate the authority of the officers of the ODPP. As correctly noted by Mr. Ndubi, the authority of the officers of the DPP is granted by the Constitution and the law being the Office of the Director of Public Prosecutions Act 2012, and does not arise from Mr. Nurdin Haji or the holder of the office. On the issue of the alleged violation of constitutional rights, including holding any of the accused persons or any of the suspects, before they have taken charges, incommunicado, when we sympathize again, those are issues that this court cannot listen to because you lack jurisdiction, and with that you have the downing tools. And finally, the most important question is whether or not you can reject these charges because of the invalidity of the charges, to wit duplicity. Mr. Ndubi has not described to you how the charges before you are bad for duplicity. Nothing at all, apart from the statement that the charges are bad for duplicity, has been told to you. In response, the charges before you are founded on known provisions of the Penal Code, constitutional to say the least. None of them has been declared unconstitutional. And to that extent, you have proper charges based on the law, a law known in Kenya as required under Article 52 of the Constitution. Further, under Article 89.5 of, Section 89.5 of the Criminal Procedure Code, 89.5, which is the only provision this court would invoke to reject charges. The only reason you could reject charges is that the charges do not disclose an offense known in law. Count 1 is founded on Section 89.1 of the Penal Code. Count 2 on Section 308.1 of the Penal Code. Count 3 on Section 511 as read with 510 of the Public Order Act. Count 4, which may be the newest of the charges, is under Section 4A of the Narcotic Drugs and Psychotropic Substances Act as amended in 2022. And finally, count 5 is brought under Section 771, which has been subject of constitutional litigation prior. And the court upheld that that Section 773 is constitutional within Kenya. Similar to Section 5, which also has been subject of litigation and has been found to be sound. To that extent, you have proper charges before you. But finally, even if there were alleged, violations of fundamental rights and freedoms as alleged by counsel, then the only remedy would not be to reject the charges, but to seek constitutional litigation and damages before the High Court of Kenya under Article 165. Having said that, we humbly ask you that for good order, let us proceed to take the plea and then handle the issues arising after we've taken the plea. Thank you.